competency, and proficiency of Lieutenant Colonel Otto and the reliability and the functioning of the laboratory according to international standards. Defence Counsel did not challenge the reliability of the equipment or machines used or the correctness of specific results unless specifically pointed out. In 2001, defence expert Dr. Antonel Olkers started DNA Biotech and serves as its CEO since then. A curriculum vitae, which on the face of it is impressive, was attached to a report dated 6 October 2017. Her skills and experience included DNA isolation, DNA quantification, and so on. She has 18 years' experience in the interpretation and audit of forensic DNA evidence. Her mandate was to assess the scientific validity of the results reflected in the reports compiled by Lieutenant Colonel Otto and Warrant Officer Nell. At most, it was the defence case that a sample taken near where Marli van Breda's body was found presented with foreign alleles not belonging to the family. Lieutenant Colonel Otto disagreed with the defence expert Dr. Olkers in this regard. The result of the blood or DNA found in the corner of the shower floor in the first bedroom was also challenged to the effect that it covers 2 donors and not 3 donors, as Lieutenant Colonel Otto testified. Lieutenant Colonel Otto conceded that that could indeed be the case. The defence argued that the results of 40 other samples, whereas less than 1 nanogram of input DNA was used in the PCR, should be ignored as it was of no value. Further, it was defence case that the bulk of the DNA results were scientifically invalid because certain standard operating procedures were not complied with. The functionality and non-accreditation of the FSL in Plattekloof was also challenged by Defence Counsel. Lieutenant Colonel testified the Profiler Plus kits used in SAPS laboratories are bought from the USA and are in accordance with international standards. Laboratories all over the world make use of it. It must have certain loci, as genetic markers or loci genetic markers, which must be scientifically accepted. The witness testified that FSL now uses the Identifier Plus kit, which it identifies 15 loci. It might have a better identification and match probability. In 2015, other countries like Australia and the UK use 16 and more loci. The STR kit was used in 2015 because the identifier kit was not validated by then or at the time. It would not have affected the results if the new kit had been in use. The one might have had an extra allele to differentiate between family members. The equipment manufacturers appear to have their own guidelines for use. The Pretoria laboratory has to validate the process, but the Plattekloof laboratory does a verification as well. Lieutenant Colonel Otto testified that for 20 years she has been working at the laboratory, the SAPS laboratory, which was not accredited with SANAS. It's SANAS. The only difference between them and an accredited laboratory is an audit by SANAS. The SAPS laboratory is audited internally and not by SANAS. It is an international standard to be accredited, and accreditation of the laboratory is not, and I emphasize, the accreditation of a laboratory is not a legal requirement in South Africa. In this matter, 216 samples were analyzed. Lieutenant Colonel Otto testified they did not struggle to get optimal DNA. Dr. Olkers testified that this was the case with more samples than she had ever seen. Advocate Kompering, who appeared with Mr. Bertha for the defence, had it in Exhibit 88810, containing extractions from the results contained in ZZ1. That is the DNA profiles of 5 reference samples of the Van Breda family and the mixture of alleles of the DNA profiles of the 5 family members. The mixture of all the alleles of the DNA profile from the reference samples of Rudi and Henri gave the same profile. Teresa contributed 50% to the DNA profile, and the rest would differ. The mixture profiles looking at the alleles work would be the same, looking at the profiles would be the same, where there's a mixture of the accused, Rudi and Teresa, or Teresa and Rudi. But the gender would differentiate. However, both mixtures would include X, Y, indicating the male allele. Lieutenant Colonel Otto testified that she included those profiles that she could in respect of a mixture, and also looked at the probabilities. Lieutenant Colonel Otto conceded that where there was a mixture profile from the accused, Rudi and Teresa, it could very well have been a mixture for the accused and Rudi. For example, the DNA of the accused, Rudi and Teresa, found in the shower could only be the DNA mixture of the accused and Rudi. There was no distinction between the three people's STR profiles in respect of the sample found in the shower. Defense counsel indicated that it is not in dispute that the accused DNA mixed with that of Rudi was found in the corner of the shower that they utilized. Colonel Otto testified because it is a shower, the use of soap and detergents or shower gel is expected. The same sample tested positive for blood. The probabilities are slim to get body cells if a person washed himself. Body cells can be excluded because of the soap, shower gel, and cleaning products used in a shower. Blood is more resistant to normal detergents. The accused offered an explanation for the fact that Rudi's and his own DNA was found in the shower, namely that they occasionally used to shave in the shower. Later, the accused added that shaving in the shower was a regular occurrence and that his father also shaved in the shower. The accused said that if the DNA in the shower was not blood, then it might have been there as a result of them touching that part of the shower. Dr. August dealt with the number of STR loci used in DNA profiling in paragraph 3.3 of her report. Dr. August illustrated in paragraph 3.5.3 the problematic nature of using only 9 STR loci DNA profiles. They set out this in more detail in the summary, and Dr. August dealt with the interpretation and the reporting of certain mixtures in paragraph 3.6 of the report, Exhibit E. According to Dr. August, it appears that Lieutenant Colonel Otto only took the qualitative aspects of the DNA profiles into account when she reported the findings pertaining to the following DNA mixture results. Namely the nail scrapings, left hand of the accused, corner of the shower floor, and 3 shorts of the accused. Dr. August testified the Lieutenant Colonel's report could have left the impression that the DNA of Teresa, Rudi, and the accused was present in the aforementioned samples. However, during cross-examination, Lieutenant Colonel Otto confirmed that each of these samples could, with equal possibility, have been a mixture containing the profiles of only Rudi and the accused. According to Dr. August, it only takes the qualitative aspects of the DNA profiles into account. In other words, one could not distinguish between 2 or 3 members of the family's qualitative profiles. When taking all the data, qualitative and quantitative data into account, one alternative could be eliminated. State counsel, that's Ms. Galloway, questioned the fact that the witness used 2 of the 40 samples that she said should not be used for further analysis to make calculations to determine the amount of male and female DNA in the samples. The witness herself made calculations on his alleged flawed results. Dr. August was confronted with the fact that she used the same data to say that the court could just read 2 profiles into the sample and not 3. Dr. August said she took the document that Lieutenant Colonel Otto made, based her opinion on to show how wrong Lieutenant Colonel Otter's conclusion was. The court accepts that Lieutenant Colonel Otto included all the profiles that could be read into a mixture sample. It cannot be said that Lieutenant Colonel was dishonest in this regard. She conceded the qualification immediately. However, it can be misleading if the result is not qualified and by not stating all the relevant information affecting the interpretation of results. Forensic analysts should be mindful of clouding the interpretation of ambiguous results. Dr. Alkers listed non-compliance of the process followed by FSL. She testified that the proficiency of 6 analysts that worked on this case, including Lieutenant Colonel, was based on a challenged proficiency test. Therefore, they were not regarded as proficient by Dr. Alkers. Lieutenant Colonel had testified that the analysts who dealt with this matter are all competent and proficient and are specialists. It was never put to the state witnesses that the other analysts were not proficient. Dr. Alkers testified it was indicated to defense counsel that she did not know why they did not raise it. Once again, she based her opinion merely on the answer given regarding item 3 of the test. The court is satisfied that Lieutenant Colonel Otto's competency is established beyond any significant doubt. She is a seasoned and qualified member of the FSL with obvious and extensive experience. Dr. Alkers had an issue with the absence of a date on a proficiency certificate issued to Lieutenant Colonel Otto. Dr. Alkers said the ISO guide stated the certificate had to be dated. The 1997 certificate received by Lieutenant Colonel Otto could not be backdated. The ISO guide was issued in 2005. If the certificate was issued prior to the ISO guide coming into operation in 2005, the witness accepted the certificate could be backdated. Another alleged non-confirmation was that an alphanumeric sign did not appear on the relevant documents as required. Dr. Alkers conceded that there was an alphanumeric number on the document and that the letters KS or K5 were indicated as the KS were indicated as the signature. Lieutenant Colonel Otto testified the SOPs put control measures and check measures in place and checks measures in place. That is quality control measures. So if they get the result, they can accept it because the sample moves through the process and passes all other control measures. She will be able to pick up if the SOPs were not followed, whether there is a failure, negative or positive control, or samples have been switched, or in the case of contamination. There is also a database for the analysts, calling the personnel elimination database. Dr. Alkers testified that 40 samples with less than 1 nanogram of input DNA that had been analyzed was not in accordance with SOPs. SOP is a standard operating procedure. SOP B1117P, B100017P, determines that the amount of DNA to be amplified is the FL-STR Profiler Plus amplification kit should be between 1 and 2.5 nanogram, unless the sample was highly degraded. If the DNA amount was too small and below the threshold, it was not always true that there would be no result. It's called stochastic effects, and it means that the DNA result might no longer hold true. Dr. Alkers said that the forensic evidence should be ignored where the input DNA was below the threshold and less than 1 nanogram for purposes of crime detection. State Counsel, in my view, correctly pointed out that the FSL is a forensic laboratory, not a research laboratory with perfect samples. There are not always optimal samples on the crime scene. The crime index stated that 0.001 nanogram per microliter could be used. Dr. Alkers conceded that crime samples were more challenging and said that 0.02 nanograms could be used. Furthermore, State Counsel put it to the witness that Lieutenant Colonel Otto testified that they had no problem in finding DNA in the sample. Dr. Alkes responded that the answer found was not necessarily valid. Science worked with a standard. However, Dr. Alkes could not say that the results were wrong or false. Importantly, Dr. Alkes conceded one could not get different profiles even if less DNA was used. The results were merely technically invalid. The amount of DNA was more relevant in old techniques used, not with the PCR system. The PCR system prefers a lesser amount of input DNA. The 40 samples had been loaded with less than 1 nanogram, but the results were valid and reliable. One should look at the peak heights rather than the cutoff values. Should the DNA be degraded to an extent, there would be no result. Lieutenant Colonel Otto testified that quality rather than quantity was important, rather than the issue of input DNA concentration. They definitely found sufficient alleles to have made a reliable and valid profile. In respect of paragraph 2, Exhibit AAA7, Lieutenant Colonel Otto testified that she thought there were other S samples apart from the 40 samples which had more than 1 nanogram input DNA concentration pertaining to those specific exhibits. For example, there was a blood sample and a touch DNA sample pertaining to the handle of the knife. Defense counsel said that it was not disputing that less than 1 nanogram DNA could be used to obtain a DNA result. Getting a result is not important following the SOPs, that's according to defense counsel. During the defense case, Dr. Alkes was questioned about the extent to which the person without proper footwear compromises the veracity of the results. Dr. Alkes could not comment on the likelihood of it impacting on the DNA result or the finding of the FSL. Defense counsel then made the concession that Exhibit AAA8, that's the one where there's a shoe in the picture, indicated that defense was not relying on the photographs. Defense counsel is entitled to challenge the state case. Sorry, maybe I read that wrong. Defense counsel then made the concession that Exhibit AAA8 was only, in quote, a sideshow, and indicated that the defense was not relying on the photographs. Defense counsel is, of course, entitled to challenge the state case in every respect, but it has to be done within reasonable limits. Defense counsel should refrain from wasting court time with sideshows, merely use sideshows which merely cloud the issues. It is not in the interest of justice to do so. Dr. Alkes conceded that she had never done a proficiency test, internal, external, or international. So she was not tested in respect of aspects involved in the current case. Dr. Alkes was not an impressive witness. She had to be asked continuously to answer questions more pertinently. The witness was reluctant to make concessions where it was appropriate and insisted on a formalistic academic approach. Dr. Alkes tended to give vague answers without answering questions posed to her properly and directly. At the end of the day, the accuracy of results is all that matters. Dr. Alkes conceded that she had no experience in a forensic laboratory. The witness merely had an academic background in a laboratory and ran courses. Of great importance is the following. Even though the defense team had access to the DNA samples taken at the crime scene, they opted not to retest it. The witness says she advised counsel in this regard. She did not know why they did not request retesting. Dr. Alkes said retesting the sample was not part of her mandate. I underline the word mandate. Although the defense does not have to prove anything, it would be in the simplest of exercises to test a few random samples to effectively test the validity of the results. It is also true that defense counsel is entitled to test the state's case. But there should be some limit to what is called fishing expeditions with sideshows. In this matter, the accuracy of the result is not shown to be incorrect. Dr. Olker's role and evidence amounted to an administrative audit of the processes involved in the DNA system. Dr. Olker testified the results of the sample mentioned above were scientifically invalid, in other words, technically invalid, because SOPs, the standard operating procedures, were not strictly followed. She could not categorically state that the results were inaccurate. This could have been easily done. The court is mindful of the distinction between judicial and the scientific measure of proof. The scientific measure of proof is the ascertainment of scientific certainty, whereas the judicial measures of proof is the assessment of probability. Speculation and possibilities cannot distract from the evidential value of the results in the absence of proof of the inaccuracy of the results. The relevance of the bloodstain patterns in the DNA results. Captain Joubert attended the crime scene for the detection and the identification of possible blood and bloodstain patterns. Captain Joubert marked the identified bloodstain patterns within the crime scene and documented the stains and platters by means of photographs and sketches with measurements. He requested Sergeant Hitchcock to document the identified bloodstains and patterns and to collect samples of the identified bloodstains. The witness made certain assumptions when compiling the report. Inter alia the following. 1. All reddish-brown fluid and staining at the scene had the appearance, behavior, and context consistent with blood. And 2. That all the bloodstains were deposited contemporaneously, brackets occurring at the same time, to the events surrounding the incident. The accused testified that he was dressed in his grey sleeping shorts with boxes underneath and a pair of socks. The grey shorts belonging to accused had multiple spatter bloodstains on the front. On the frontal aspect of the grey short, 67 spatter bloodstains were identified and documented. The spatter bloodstains suggest impact as the possible deposition mechanism and were probably created as a result of force applied to the blood sources like a wound. 32 of these spatter stains belong to Rudi, 9 to the accused, 5 to Martin, and 2 mixed samples respectively with Teresa and Rudi, as well as Teresa, Rudi, and the accused as the possible donors, which should be only Rudi and the accused. None of the stains originated from Marli. The spatter blood stains indicated full penetration of the fabric knit by the blood during deposition. 14 transfer blood stains were identified on the grey shorts, suggesting objects contaminated with the blood came into contact with the grey shorts. A blood clot on the grey shorts was most likely created by contact between the blood source and grey shorts. No DNA could be extracted from the blood clot sample. 3 non-spatter contact stains emanated from Rudi were on the accused shorts, and the 2 non-spatter stains from the accused on the frontal part of the shorts. There were also possibly urine stains on the grey shorts, as can be seen on the photographs 182 and 183. Captain Joubert's conclusions and a summary of the bloodstains with regards to the crime scene are contained in paragraph 37, Exhibit DD1. The following relevant aspects were inter alia his conclusion. 1. There were a number of stains that were most likely made by EMS personnel based on the scene and the pictures. The bloodstain pattern suggests Rudi was dragged or moved from the bed onto and over the carpet between the beds towards the wooden floor. The bloodstain pattern suggests Rudi was moved through the pool of blood, which resulted in the creation of swipe and wipe patterns. 3. The duvet from the accused's bed was removed after the blood shedding event. 4. Rudi's blood had time to clot before he was moved. Time passed before his upper body on his bed was disturbed. The bloodstain pattern further suggests that Rudi was also stationary for a period of time on the bedroom floor as a pool of blood was created. 5. Spatter on the frontal aspect suggests the grey short was in close proximity to Rudi and Martin when force was applied to the blood source of those victims. The bloodstains further suggest that the grey short was facing the blood sources when force was applied to the blood sources of the victims and Martin. The bloodstain documented as Exhibit 120 to 187 contained a blood clot which suggested an object contaminated with clotted blood made contact with the shorts, which resulted in a transfer of blood. The grey shorts were exposed to multiple bloodshedding events during the incident, and take into consideration the different DNA profiles obtained from the bloodstain samples collected from the shorts, and also the location of these bloodstains, including the transfer bloodstain. 6. The spatter bloodstains on the white socks showed that it was in close proximity to blood sources originating from Teresa and Rudi. The spatter at the back of the white sock suggests the wearer's foot was positioned in a manner in which it exposed the area to a bloodshedding event. The pair of white socks was exposed to were exposed to multiple bloodshedding events during the incident, taking into consideration the different DNA profiles obtained from the bloodstain samples collected from the socks and also the location of the spattered bloodstain. 7. There was no disturbance of bloodstains on the handle part of the axe. Now, with reference to the relative positions of the victims and attacker during the incident, Captain Joubert documented and testified as follows. The accused was standing next to Rudi's bed when the victim was attacked on his bed at point CS24 on photographs 103. Rudi was attacked on his bed, was lying on his stomach with his head facing the adjacent wall. Martin was most probably attacked attending to his son Rudi on the bed when he was attacked by the attacker on Rudi's bed. The attacker was standing in the vicinity of Rudi's bed when Martin was attacked. Teresa was most probably attacked in the doorway of the first bedroom. Marli sustained the injuries during the confrontation with the attacker, most likely in the same area as Teresa. According to Captain Joubert, the bloodstains and bloodstain patterns observed did not support the sequence of events presented by the accused in his statement. The events surrounding the knife presented by the accused in his statement are inconsistent with the events identified through bloodstain pattern analysis and the law of superposition. Events pertaining to the grey duvet belonging to the accused, marked Exhibit 138, were identified suggesting movement and interaction with the environment before the grey duvet was in its final position. 4. The victims were attacked in a short period of time, after which a time lapse occurred, and the victim, Rudi, was moved or dragged from the bed and handled in front of the two beds in the bedroom. Thereafter, the grey duvet, marked Exhibit 138, was placed or thrown adjacent to the victim, Rudi. During the incident, the knife and the grey duvet were in contact after the knife was in contact with the victim, that is Rudi's blood. There is no indication of evidence or evidence identified supporting the victim, Rudi, being mobile after sustaining his injuries. The events surrounding the confrontation, following the suspect falling and fainting on the staircase, presented by the accused in his statement, is inconsistent with the flow patterns identified on his chest and left arm, which also suggests minimal to no movement of the upper chest and the left arm of the accused after sustaining his injuries. Bloodstains and bloodstain patterns were identified in areas which are not entered by the accused, which was inconsistent with the event actions presented by the accused in his statement. The position of the accused during the events within his bedroom was inconsistent and was not supported with the bloodstains. The evidence does not support the actual events described in the accused statement. The witness indicated that he could not rule out the possibility of staging. Captain Joubert explained that staging was the alteration or creation of evidence to direct the investigation away from the perpetrator. That's the order meaning of the concept staging. Defense counsel argued that the accused maintained from the outset that he was in close proximity to Rudi and Martin when the bloodshedding events occurred, hence the blood spatter on his shorts. Counsel argued this evidence does not warrant an inference that the accused was the attacker as the only reasonable inference. This statement by defense counsel is in fact incorrect. The accused said in his statement to the police that he remained in the bathroom during the attack. Since the start of the trial, the accused version was that he was in the corner of the room in the vicinity of the bathroom. However, there was no spatter on the bathroom door or either side of the walls outside the bathroom. Captain Joubert testified one would have expected blood smatter in that area as blood was deposited on his shorts. During cross-examination, the accused conceded that one would expect blood spatter on the surrounding wall and door. Captain Joubert testified that there was blood spatter mainly on the shorts and socks of the accused. If it was in the vicinity of the spatter or in close proximity of the attacker, Rudi and Martin would have expected blood spatter on his body as well, not only on the shorts and socks, whether he was closer to the bathroom in the room or further away. Captain Joubert said it was a possibility that the accused cleaned himself because of the blood being limited to his shorts and socks. Defense counsel argued that the accused had maintained from the outset that there was more than one attacker in the house that particular morning, hence the absence of Marli's blood on the axe and his clothes. This statement is once again not correct. A second attacker was not mentioned from the outset, neither in his statement to the police nor to Captain Steyn at the scene. The possibility of a second axe being used was only proffered during the trial, after the DNA results were known. The accused mentioned in general terms to Ms. Philander that 3 adults and a teenage girl had been attacked with an axe during the emergency call. The court makes no adverse finding with regard to the information of an axe being used in the attack on Marli due to the general terms of the statement. The court has already dealt with the submission regarding the absence of Marli's blood, DNA, earlier in this judgment. Whether the bloodstain patterns analysis and DNA results merely place the accused on the scene or identify him as the attacker, it is significant that nothing in the forensic evidence categorically excludes the accused as the attacker. Captain Candice Heloise Brown, and I deal now with the relevance of impact marks on the crime scene. Captain Candice Eloise, how do you say her name? Eloise Brown is stationed at the ballistics section of the Forensic Science Laboratory, FSL, in Plattekloof since 2004 for approximately 13 years. She received training in various components of ballistics. On the 28th of January 2015 at 9:30, she visited the crime scene to examine certain impact marks. The witness compiled a report dated 20 February 2015, which was handed in as Exhibit YY. The scope of the forensic examination was crime scene examination, reconstruction, and scene photography. Pertaining to the crucial question whether the axe could have been thrown to make the impact mark D, according to the accused version, Captain Brown testifies as follows. Exhibit 1 was not a throwing axe. And I may ask, from what I learned in this case, there was actually such a sport. In any case, the axe could land on 4 areas, namely the butt, the head, the sharp edge, or the handle. If one were to throw the axe, you'd have a 1/4 chance of it landing on the sharp edge or on any of the other areas. The brick behind the plastered area was exposed inside the impact mark. The impact was deep, and therefore the brick was exposed. So basically, the impact mark would have had to move beyond the 10 to 15 millimeter plaster area in terms of the South African building standards to expose the block. Any object flying through the air decelerates in velocity and speed. When taking into consideration Newton's law of motion, one would definitely expect that an object that has weight and flying through the air to make such a mark landing on the sharp edge side. So the version contained in the plea explanation is possible, but highly unlikely. The witness confirmed that variables play a role, that is, the strength of the person, how far away the person was, and so on. Captain Brown based her opinion on her years of experience in the ballistic field and fitted the axe into the damage mark D. She did not do other practical experiments with the axe and the wall which might impact on the weight of the evidence. The court notes that the mark in the wall is rather straight and did not create a mark with an angle of some sort. A controlled action with an axe will probably create more straight or linear marks than throwing an axe. The appearance of the victim's wounds inflicted with controlled blows with the axe present with similar straight lines. Her opinion is also supported by the evidence of Captain Joubert to the effect that the damage above the staircase was probably caused by controlled action and not the throwing of the axe. Captain Joubert testified that he asked about the position of the accused after the attack had fled, but he was informed that the representative of the accused did not provide cooperation. He did similar experiments with different weapons. The accused was also not sure where he stood when he allegedly threw the axe, which makes a accurate scientific process more complicated. There was no expert evidence to the contrary, which was presented by the defense in this regard. Although it was put to the witness, the defense ballistic expert simulated the axe throwing. It was submitted on behalf of the accused that the quality of the expert evidence was so poor in the absence of following a scientific process and doing experiments that it was not necessary to present any countervailing evidence other than the accused's own evidence. That's what defense counsel said. Warrant Officer Hitchcock was to do with the shoe prints at the crime scene. He identified certain relevant bloody shoe prints from the several prints inside and outside the house. Captain Dani van der Westhuizen, a forensic field worker and shoe print analyst stationed at the Provincial Crime Syndication Unit, guided and advised Warrant Officer Hitchcock and other officials how to document the shoe prints and what would be relevant. He also identified the different patterns of shoe prints when walking through the crime scene. The uncontested testimony of Sergeant Kleinhans was that there were no bloody footprints on the stairs upon his arrival, as can be seen in photographs 124 and 126. Christian Kuchenberg confirmed that the prints on the scene had to be the bloody footsteps of the emergency personnel, as can be seen in the photo album, when they were assisting the injured Marli. The fingerprints found at the scene, Sergeant Jonathan Oliphant from the local Criminal Record Centre in Beaufort West found 53 fingerprints in total. The witness distinguished between usable and unusable and negative fingerprints. In case of unusable fingerprints, all 7 points required by the court to identify a print were not available. One could still identify a person though. He compared the usable prints with the known prints furnished to him. He had the prints of the accused and the rest of the family, as well as from the domestic workers and the gardener. A copy of correspondence between the investigation team and the LCRC containing an elimination report was handed in as Exhibit MM. On page 2 of the report, the names of 15 persons who had been arrested for crimes committed at the Zalze appeared. None of the 15 persons could be linked with the prints on the crime scene. The prints of James Reed John were found on the boot of one of the motor vehicles. No prints or hit of a possible suspect were found. Of significance is the fact that the unidentified prints originated from several persons and not just one person, which possibly could explain the number of unidentified prints. In this matter, the alleged intruder wore gloves, so one would not expect to find the fingerprints on the scene. If the intruder had indeed been accompanied by a second person, such a person would, with all probability, would have also worn gloves as well, taking into consideration the dress code or modus operandi of the intruders. Sergeant Oliphant collected the axe and the knife from the scene and examined it for fingerprints. No fingerprints could be found on the axe. It was possible to get prints on wood depending on the surface, and it's not unusual to find fingerprints on wood. The tests performed to identify fingerprints had no effect on other further forensic tests. The witness testified that 3 prints were found on the knife, of which 2 were unidentifiable. The right thumbprint of the accused was found on blades, 5 to 6 centimeters from the tip of the knife. The print pointed towards the handle of the knife. If the knife points down, the thumbprint pointed up. An enlargement of the blade of the knife was added in as Exhibit MM1. 2 smeared, unidentified prints were found. The identifiable print on the tip of the blade belonged to the accused and was actually a double print. It was indicated with circles by the witness. In this matter, the accused admitted from the outset that he had handled the knife after an altercation with an alleged intruder. The findings of the expert pertaining to the prints on the knife are uncontested. Therefore, the issue of the reliability of the prints, even in the absence of an explanation with regard to the points of similarity by the accused, can be accepted. The evidential value of the evidence needs to be approached with caution because of the lack of the explanation of the age of the identifiable and unidentifiable prints. The accused was asked to explain how the knife ended up under Rudi's bed. The accused offered 2 explanations, namely that a knife could have bounced there when he dropped it, or it could have been pushed there by Rudi when he was moving around. In the light of the probabilities, the explanation given by the accused does seem to be possible, but not necessarily plausible. Professor Dempers and Dr. Timmersma were of the opinion that it was unlikely that the knife would have been stuck in the accused's body if the accused was moving around. There are far too many possibilities and insufficient evidence for the court to make an inference regarding the fingerprints and the position of the knife. The bottom line is simply this, that it is unlikely that the intruder would have left fingerprints with gloved hands. Only the accused's thumbprint was on the knife and Rudi's DNA. If there was no intruder, the knife could possibly have been used in a fight by members of the Van Breda family amongst themselves at some stage in the course of the evening or night, or simply by the accused inter alia to stage the wounds and the scene. The number of intruders. It is the accused's version that more than one intruder entered the Van Breda residence that particular night. The issue of the number of intruders, the description of the intruders, and the motive of a possible intruder needs to be scrutinized. Janine Verlander testified that the accused mentioned one attacker to her, but he did not say that they, inverted commas, ran away from the attack. Sorry, I read it wrong. Janine Verlander testified that the accused mentioned one attacker to her, but he did say that they ran away from the attack. The accused alleged in his plea explanation that he heard angry voices of more than one person somewhere else in the house after the attacker fled out of the bedroom on the first floor. The accused testified in his evidence in chief that he did mention to Colonel Beneke that there was more than one intruder. When asked by his counsel why he did not tell Sergeant Malan to rectify his statement before signing it, the accused explained he did not feel like it after retelling the story of a very traumatic experience several times at that point. The police were still gathering information to catch the perpetrators at that point. There seems to be an intelligent person and must have realized the importance of information about the offenders simply to enable the police to pursue them. During cross-examination, the accused advanced another reason for the absence of this information in his statement. He said he specifically mentioned the second attacker or intruder, but did not notice the omission after the second intruder, about the second intruder when he read and signed the statement. He spoke at length about the two intruders and said he did not know why the police left it out. The accused said he was surprised it was not in his statement. He did tell the police about the second attacker or intruder, so he accepted they knew about it. I come to the accused as a witness and his version. Sorry? I lift up the page. Yeah. Sorry. Thanks. Yeah. Sorry, before that, I do a description of the attackers. According to his plea explanation, the accused thought that the attacker was a black person. The accused further alleged that the attacker was dressed in dark clothes. He wore gloves and a balaclava-type mask. In a statement to the police, the accused described the attacker as a strong, well-built person, 1.86 meters tall. The accused stated the attacker wore dark jeans, a black jumbo jersey, black gloves, and a homemade dark grey mask. He said he would recognize his eyes and voice of the attacker. He gave a similar description of the attacker's clothing during his testimony, except for the jeans. During cross-examination, the accused testified that he thought it was a black man because he noticed a very deep contrast between the whites of the attacker's eyes and the skin around his eyes. In other words, he based it on the skin coloring around the attacker's eyes. The accused testified black would mean colored as opposed to white, because the word colored is not used overseas. When it was pointed out by State Counsel that some white people are also rather dark-skinned, the accused agreed. When asked why he did not tell the police that he had seen too little of the attacker's face or features to determine his race, the accused responded by saying that he actually did. He said he was told to choose a race despite being unsure because Colonel Bieneke was unhappy with his description. Later he said it was not strictly true that he could identify the attacker on his eyes and voice. However, he told the police that those are the only two things that he could possibly use to identify the intruders. During cross-examination, the accused conceded that he gave a very stereotyped description of the attacker who executed the attack, and it boiled to an unknown black man wearing a balaclava and gloves. The accused agreed with the statement of his counsel that no one would be able to trace the attacker based on his description. The accused explained that he did not have a lot to go on. I come to the accused as a witness and his own version at the scene. Captain Nicholas Steyn from the detective branch in Stellenbosch was asked to establish the accused's version of the events. The accused was not a suspect at the time and treated as a victim, according to Sergeant Kleinhaus, Dr. Bertzer and Sergeant Marli. The accused told his version of the events while he was sitting in the ambulance at the crime scene and without the witness questioning. The accused communicated with the witness in English. He told the witness that he had been in the toilet in the early hours of the morning when he heard noises. He looked through a gap in the toilet door where he saw someone attacking his brother Rudi. The accused said that he had shouted and then his father came into the room and the suspect attacked his father. His mother and sister came in and the suspect attacked them too. During cross-examination, Captain Steyn testified that it's possible that he misunderstood the accused to the effect that the accused's mother and sister were attacked outside the bedroom and not inside the bedroom. The accused then confronted the suspect and took the axe from him. The suspect stabbed the accused on his side with a knife. He chased the suspect from the room and down the stairs. He threw the axe at the suspect but missed and hit the wall. The suspect ran out the back door and the accused returned to the stairs when he saw his mother and sister lying on the landing, and then he fainted. Once he regained consciousness, he Googled the police emergency number because he did not have the number on him. He contacted the police. Captain Steyn conceded that it was possible that the accused said he Googled an emergency number and not a police number. The accused said he could not remember how long he was unconscious, but when he regained consciousness, he did the Googling. The trial within the trial. The trial within the trial relates to the admissibility of a statement made by the accused prior to his arrest. It is made to Sergeant Clinton Milan. The admissibility of the said statement was contested on the basis that the accused's constitutional rights were violated, in that he was a suspect and as such enjoyed the protection of Section 35 of the Constitution, or at the very least the judge's rules. Counsel for the accused suggested that the manner in which the accused was treated prior to the taking of the statement supports the notion that he was a suspect at the time the statement was made. The state argues that the accused was not a suspect at the time. The evidence at the trial within the trial was restricted to that of Milan, and the only defense witness, Mr. Andre de Toy, has further agreed with the parties that the evidence of Drs. Van Zyl and Albertser be incorporated in the trial within the trial. The onus, of course, on the state to prove the admissibility of a statement, which the defense actually later ended up in evidence as Exhibit SS. The defense ended up in evidence in the trial within the trial. The content of the statement was essentially the same as the accused version in the plea explanation. It is not a confession and does not contain any admission. It is a witness statement which describes the sequence of events of what transpired at the time of the commission of the offences. At the material time, the accused was one of two surviving members of the family, but the only person in a position to assist the police as to what or who had attacked him and his family that night. At the time, there was no incriminating evidence against the accused, and quite patently, when making the statement, he was neither an arrested, detained, nor an accused person. The contents of the statement are not in effect disputed. The accused does not suggest that the statement was taken under duress or made involuntarily. It seems that he fully cooperated with the police. The statement itself, Exhibit SS, was ostensibly handed up in evidence for the purpose of attacking Malan's credibility. The principal attack levelled against him was that he did not record the statement using the ipse dictus or the precise words of the accused. The accused was unhappy with the spelling mistakes and grammatical errors. Malan's mother tongue, of course, is Afrikaans, and he typed what he understood the accused, a sophisticated English person, to say. It was not suggested by the defense counsel that Malan did not record the version given by the accused. The language and grammatical errors do not in any way affect Malan's credibility, either adversely or at all. In signing the statement, the accused did not object to the details or content of the statement. In other words, it was not alleged the content of the statement does not emanate from the accused. There was the suggestion put to Malan that the accused was told by Colonel Bieneke that he did not believe this, quote, bullshit story, close. If that is true, Colonel Bieneke at least started the interview with a high degree of insensitivity. It is unlikely that Colonel Bieneke could have come to this conclusion so shortly after attending the crime scene. In any event, the allegation not supported by any evidence, and of course the accused did not testify to this effect. With regard to determining whether the accused was a suspect or not, the only relevant evidence is that of Malan. Du Toit, the sole witness for the accused, could not be of any assistance to the court in deciding this issue. Du Toit, in fact, does not take the matter any further, other than confirming by inference that the accused was allowed contact with his family and confirming by inference that the accused was allowed contact with his family and friends, received items from them, and freely allowed to leave. Nothing stated to him by the police officers implied that the accused was a detained person or a suspect. Malan was criticized by defense counsel for apparently inconsequential matters, such as inaccurate or vague entries in a pocketbook, details of time, and other related matters. Malan was not involved in the investigation of this matter, save for accompanying the accused to the district surgeon and the taking of the statement. He would not have had an undue interest in the matter, and in my view, he was a good and reliable witness in respect of the material aspects on which he testifies. Malan's testimony is referred to in the following paragraph. The accused had been a victim who had survived an attack on his family, had been treated in an ambulance and then taken to Dr. Albertse to record his injuries. That is, as a victim of crime. The latter, in fact, standard police practice. The police were eager to take his statement, as he was at that stage the only source of information regarding possible suspects. It was quite obviously a very serious, violent and brutal crime. The questioning of the accused and his statement was to determine what probably had happened in order for the police to trace the suspects. The accused did not indicate that he was unwilling to talk to the police, and there was no evidence incriminating the accused in the commission of the crimes, which placed him in a position to provide an explanation. The accused was calm and able to give a coherent account of how the family was attacked. The accused read the electronic version and was satisfied with what had been recorded. The accused was thereafter free to leave with his family. The accused failed to testify or lead any evidence to gainsay what Milan had stated during his testimony. It was reasonable for the police to seek to finalize the formalities and obtain information about the events at the earliest possible opportunity from the only available eyewitness. There was no onus on the accused to testify or prove anything. However, the failure to testify is a factor to be taken into account, as there is no evidence to rebut the material aspect of the state's case. There is no evidence before it for the court to find that the accused was viewed as a suspect at the time, and he was initially interviewed and the statement recorded. In the circumstances, the court finds that the statement made with the accused was as a witness and not as a suspect. In any event, the degree of prejudice, if at all, against the accused in admitting the evidence is negligible, and that most of the evidence is already before the court, either in the plea explanation or in the verbal statement given by the accused on the scene to Captain Steyn. Moreover, it does not contain either admissions or a confession. In the light of the peculiar circumstance of this case, public interest would dictate the admission of the evidence, as the police were faced with a serious crime and the accused was the only source of information which could lead to the culprits being traced. The statement marked SS was accordingly admitted into evidence for these reasons. That ended the trial within a trial. The discrepancies between the plea explanation of the accused, his statement to the police, and his testimony in court. It was argued that the accused version remains in essence the same, but there seem to be differences in some important respects. Defense counsel argued that the accused was in a post-ictal state when he deposed his statement. This possibility is not based on reliable evidence, but rather on an uncertain, backdated diagnosis by Dr. Butler, without examining the accused at the time of performing tests to confirm his diagnosis. Furthermore, it was submitted that the few discrepancies between the accused's police statement and his later versions in his plea explanation and evidence court can be explained and accounted for by his physical and mental state, compounded by the method and manner in which his statement was taken down by the police. Therefore, the statement cannot be used as a reliable comparative device for the purpose of incriminating the accused. State counsel submitted that at the time of deposing to Exhibit SS, the accused had no insight into the forensic evidence, that being the forensic pathology reports, the DNA results, the bloodstain analysis, and the crime scene investigations. The accused testified that the police did not deprive him of food intentionally, and he was not starving at the time. He did eat a sandwich and flavored yogurt when he was brought food. The police also did not intentionally deprive him from sleep after. He said he was willing to work with the police and gave them as much as possible information to catch the killer. He absolutely wanted to work with the police. The accused testified that at the time he did not think
that the police actions were irregular. He testified that certain aspects in Exhibit SS were incorrect, but he said that he signed it because he could go home. The accused said he was not thinking clearly at the time. He says further that if he had legal advice, he'd have understood the situation he was in better. He said he would not have changed anything of what he had said to the police. The document or outcome would have been more accurate. The accused said the statement is not his version given to the police. The wording in Exhibit SS was inaccurate. The accused said he was not suggesting that the police made it up lies, but it's not the words he used. He said the wording was wrong, and from that unfair conclusions could be drawn. If his attorney were there, she could have worded the statement correctly. He said his complaint about the wording, not the content of the statement. The accused conceded the information contained in the statement did emanate from him in one way or another. During his testimony, the accused conceded that there were discrepancies between his plea explanation and his statement to the police. During cross-examination, the accused conceded signing an incorrect statement, but said if he knew it was going to be used in court, he would not have signed it. There should be no distinction in the mind of the deponent between a statement to the police and court proceedings as far as telling the truth is concerned. In fact, the accused conceded that he was prepared to compromise the truth under oath for reasons of his own. Furthermore, the accused said he would not have changed anything of what he had said to the police, only the document would have been more accurate. He said he was not suggesting that the police put words in his mouth or that they made up lies. He was merely suggesting that he did not use the words in the statement and cannot be accountable for the exact wording of the statement. It is true that the police statements are not perfect. All depends on the essence of the statement. Apart from spelling and grammar mistakes, the police had to be aware of the importance of the accuracy of the contents of the statement of probably the only eyewitness. It is not a matter of holding the accused accountable for the exact wording, but more so important factual inconsistencies in the sequence of events. State Counsel canvassed the statement by the accused. In his plea explanation, the accused said that Martin, Rudi, and he watched television while Teresa prepared dinner. According to his statement, Martin and the accused drank 2 glasses of red wine each, and Rudi went for a run outside. When confronted with the contradiction, the accused said it was simply not his words. He was never sure whether Rudi went for a run. However, during his evidence in chief, the accused testified that Rudi went for a run on the estate while denying during cross-examination having said so to the police. Therefore, there is not only a contradiction between his statement and plea examination, the accused also contradicted himself during his testimony. In his statement, the accused said the family had dinner at 19:15 in the dining room, and they finished dinner at 2000 hours. The accused did not mention times in his plea explanation. He testified that he could not be sure of the time they had dinner, specified at 19:15 to 2000 hours. He said it was not given by him as definite times. It was approximate times. The accused could not recall what time they finished dinner. They usually enjoyed dinner at about 19:30, it's 7:30, as most people do, I think, and it would last for about 30 to 45 minutes. After dinner, Martin, Rudi, Marli, and the accused watched television, and according to his statement in his plea explanation, the accused said that Martin, Rudi, and he watched Star Trek 2 after dinner. During his testimony, the accused denied having included Marli. He told the police which family members watched television on a regular evening. The state submitted the omission to mention in his statement that he specifically watched movie Star Trek II that evening was later adapted to explain the argument that Ms. Opthoff overheard. The accused testified his father did some work at the dining room table after dinner, and Rudi and himself watched television on the evening of the 26th January. This was 15, yeah. The accused testified that he later watched Star Trek II on the new hi-fi system together with Martin and Rudi. He could not recall what time they started watching and said Martin first did some work before they watched the film. Advocate Galloway confronted the accused with the fact that he did not mention it in his statement or plea explanation that his father worked on a laptop at the dining room table after dinner. State counsel has suggested it was mentioned in his testimony to fit in with the timeline between dinner and watching television. Furthermore, it was submitted this was done to fit in with the time frame in accordance with Ms. Opthoff's evidence. The accused said his father, working on his laptop, was not important at the time of drawing the plea explanation. He only found it relevant to mention this new piece of evidence during his testimony. The accused said he was never sure at exactly what time they started watching the movie. During cross-examination of Ms. Opthoff, it was suggested by defense counsel that the movie was 2 hours long, and that is why Ms. Opthoff had heard, and that is what Ms. Opthoff had heard between 2000 hours and midnight, the night of the murders. The accused conceded that if they watched a movie after dinner at about 2000 hours, his version would not make sense. Without the newly introduced evidence to the effect that Ms. Opthoff could have heard the movie soundtrack only at 2200 hours and not at 2000 hours. In his plea explanation, the impression was created that Martin, Rudi, and the accused went to bed after the movie at the same time, which had been approximately midnight. In his statement, the accused said Marli and his father went to bed at 2100 hours. Then Rudi and himself went to bed 2 hours later. That's about 2300 hours. The accused testified he could not recall where he was physically when he shouted for help or making a noise after he had exited the bathroom and while Rudi was being attacked. The accused said he was inferring that he was between the bottom end of his bed and the bathroom door. He also could not recall whether he remained stationary. In his police statement, the accused said that he opened the bathroom door slightly and remained in the bathroom, too afraid to go out. In his statement, the accused said that he went out of the bathroom door after he had heard his mother and the attacker had left the room. In his plea explanation, the accused created the same impression. In paragraph 24 of the plea explanation, the accused said he stood frozen and could not recall whether he remained in the same position, but that he did not open the bathroom door. But that he did open the bathroom door. The accused never said that he went out of the bathroom before the attacker left the room for the first time. The accused responded that he did not exit the bathroom. I'm reading it wrongly. It's getting late in the afternoon. Thank you, Mr. Breda. Mr. Breda is suggesting I'm getting old, so I'm getting exhausted earlier. The accused responded that he did exit the bathroom. It was not his intention to create any other impression. The accused mentioned one intruder only in his statement to the police. In his plea explanation, the accused stated that he recalled hearing what sounded like angry voices of more than one person somewhere else in the house after the attacker had fled the bedroom. In his police statement, the accused said his father jumped on the attacker, whereafter the attacker assaulted his father with an axe. His father collapsed in the room where he had been attacked. In his plea explanation, the accused said upon entering the room, his father moved towards and onto the bed over Rudi towards the attacker, was on the opposite side of the bed. As his father was lunging towards the attacker, his father was struck with the axe and went limp on the bed. He did not see his father move again. The accused struggled to explain his father's position during his testimony. Initially, he testified that his father was on his way over the bed. He testified his father came onto Rudi's bed as if he was going to make a rugby tackle on the attacker. The accused said his father was trying to attack the assailant and probably trying to protect Rudi. He denied using the words in the police statement, but said it was just of what happened. Later, during cross-examination, the accused testified that his father actually never moved over Rudi. He was struck before he was able to carry out that motion and was heading there. According to his plea explanation, the attacker was laughing whilst he attacked Martin. The attacker was laughing when he came at the accused and was almost unconcerned about his presence, that is, the presence of the accused on the scene. The statement is silent in this regard. The accused testified that he distinctly remembered hearing that the attacker laughed during the attack on his father. Before the scuffle with the attacker, before the scuffle of the accused with the attacker walked slowly towards the accused and laughed again. He testified the attacker was also laughing when attacking Rudi and after he attacked his father. The accused described it as a high-pitched giggle. The attacker struck Rudi again and giggled, and the accused had the impression that the attacker had fun murdering people. The accused said in his statement that he could hear the attacker was busy assaulting his mother in the passage. In his plea explanation, the accused said he could not recall whether he heard any sounds of an attack on his mother outside his room. The accused testified he did not hear the sounds of an attack outside the boy's room. He testified that it did not really make sense to him. He could not see what happened to his mother outside the bedroom, and he could not recall hearing anything. According to his plea explanation, the attacker came at the accused again after disarming him and grabbing the right forearm of the hand in which the accused was holding the axe. At the same time, the attacker lifted his right hand and then underlined the words, "For the first time, the accused saw he had a knife in his right hand." According to the accused, he did not know where the attacker got the knife from. In his statement, the sequence of events seemed to be different regarding the time that the accused observed the knife. When the accused managed to take the axe from the attacker, he actually saw the attacker pulling out a knife, and then the accused grabbed the attacker's right arm with his left hand. When confronted with the discrepancy, the accused testified that he did not say at the police station from where the attacker got the knife. During his testimony, a third version was given to the accused, by the accused. The accused said that the attacker recovered fairly quickly after being disarmed. He stood up and came back at the accused with a knife in his right hand. In other words, he saw the knife in the attacker's hand when being approached by the attacker. He did not see where the knife came from. In his plea explanation, the accused described the fight between the attacker himself and alleged that the attacker cut, slashed and stabbed at his chest and left arm. No mention was made of his throat. The accused struck the right shoulder of the attacker with the axe in an attempt to make the attacker let go of the knife. The attacker stabbed the accused with the knife on his left side, almost at the same time that the accused struck the attacker with the axe. In his statement, the accused said that the attacker struck at him again. The accused pulled the attacker to the side of his body, and the attacker stabbed the accused on the left side of his body. Then he, that's the accused, hit the attacker with the axe. The statement, no mention was made of the cutting, slashing, and stabbing at the chest and arm of the accused or his throat. State Counsel, or Ms. Galloway, submitted that it was rather unusual that the accused could choreograph the exact details in respect of the fight between him and the attacker. However, the accused was unable to give any information on the movement of his feet during the altercation. The court was referred to Dr. Timmersma's quotation from the textbook, Knight's Forensic Pathology, page 154, regarding the tendency to visualize a fight as a static confrontation and in an attempt to reconstruct events. The assailant merely moved his arms as if the two participants were standing still. This is an unrealistic interpretation, as all fights are dynamic, with constant movement of the bodies and limbs of both parties. The state argued that the detailed demonstration was to fit in with the evidence of Dr. Timmersma and Dr. Dempers regarding the self-inflicted injuries. The accused did not mention in Exhibit SS that he heard Rudi making gurgling sounds and saw him moving on his bed after the attacker had left the room, as he testified. In paragraph 34, 39 and 40 of his plea explanation, the accused had stated that he saw Rudi moving around on his bed rather violently before he followed the attacker and heard Rudi making gurgling sounds even after regaining consciousness on the stairs. The accused also makes no mention of this during the emergency call. State Counsel argued that this was an afterthought to explain Rudi's position and movement. The accused denied adding this information in his plea explanation to explain Captain Joubert's opinion that Rudi was handled on the scene. In his plea explanation and testimony, the accused said that he looked at the emergency numbers on the fridge door in the kitchen, but the numbers did not appear to him to be of any assistance. The statement of to the police is silent in this regard. The accused testified that he considered the numbers on the fridge and decided he could do more by other means. Calling the security, that resulted in just doing more explaining. He did not recall the 24-hour emergency numbers because he thought it would be better off speaking directly to the people that were going to help. The accused confirmed that there was a hospital number and medical number, or a medical doctor or general practitioner with a 24-hour emergency number on the list. The accused testified that the headings on the list were even in different colors so that one could scan quickly through it. When being confronted with the fact that there were two 24-hour emergency numbers on the list, the accused said he thought he could get an ambulance quicker. The accused agreed that the security could have rushed to his assistance, whilst the ambulance had to come from a distance. In other words, simply put, there were people closer at hand who could have actually helped. deal briefly with the accused's testimony regarding his behavior and other events during other aspects of the events the night of the murders. The family dog Sasha allegedly made no noise to warn the members of the household that the intruders entered the house. The accused gave a comprehensive plea explanation, but never mentioned the dog barking prior to the attack during that particular night. No statements were made on behalf of the accused that the dog barked and woke up some of the family members when the alleged intruders had entered the house prior to the attack. The accused testified that he could not recall hearing Sasha barking before losing consciousness. According to the accused, it would be probable for her not to bark when there were strangers in the house in the middle of the night. She would bark at sounds that she identifies as something exciting for her. The accused testified that Sasha was sickly at the time. She was on medication for 1 week out of a month and was disabled while on medication. The accused testified that Sasha would not really bark during that time. According to the accused, Sasha was not able to go up and down the stairs by herself, so they had to carry her up. And down the stairs. He then testified that she was not that immobile that she could not get around and get up the stairs. She just struggled. The accused said he could not recall carrying Sasha upstairs to the room the evening before the murders, so he presumes she slept downstairs. Surprisingly, the accused was not sure whether Sasha was on medication that particular night. The incident happened in the beginning of the week, so Sasha's behavior would probably have been notably different if she's received a medication that particular Monday. The accused testified that Sasha was completely deaf as well. It is not clear whether it was in general or during the time that she took her medication. It does not make sense that she would hear the doorbell, the phone ringing, and the metal from the side gate, and bark at that if she was completely deaf in general. The accused testified the first thing he registered after he regained consciousness was seeing his mother and Marli at the top. Mother and Marli at the top landing. Thereafter, the accused testified the first thing that he recalled from the morning after the murders was hearing Sasha barking at the phone that was ringing. Ms. Mpundani testified the dog would bark for a short time upon her arrival, but it did not make a lot of noise. The dog roamed the house freely. According to the accused, Sasha would have barked at Precious, whom she knew, and not at strange people being in the house in the middle of the night. She also would not have barked at strange noises outside, but she got very excited when the phone and the doorbell rang. It seems to me to be unlikely that Sasha would not have barked at the intruders in the middle of the night as she barked upon Precious' arrival and the metal sound from the side gate if the intruder came in via that route. It is also unlikely that she would not have barked in the attack upstairs, as it could not have been a quiet event in which her owners were involved. If one can refer to pet owners as owners, in the classical sense of the word. The court dealt with the concession by the accused that it would be strange that the persons who planned to enter the house and attack the family came unarmed or armed inadequately that night. The accused found it strange that the one person who went upstairs was also incidentally the same person that came from the house, was armed with both the knife and the axe. According to the accused, the attacker appeared to be unconcerned about his presence in the room. The accused testified that the attacker had to be aware of his presence. Not only did the attacker remain with his back turned to the accused, whilst brutally assaulting the other two male members of the family, he also went out of the room to attend to a female person outside the room first. The accused is a tall, well-built person with the appearance of being physically strong. There's no evidence to the contrary. By leaving the accused unattended like that, the attacker opened himself to the risk of being overpowered. The attacker's behavior seems to be peculiar. It is also peculiar that the attacker did not shout for assistance to the other intruders when he struggled with the accused or when he was disarmed. That is, when the axe was taken from him. Furthermore, it is peculiar that the attacker would approach the accused with a knife after being disarmed of the axe, while the accused still had the axe on his possession. The accused was too scared to help any member of his family and only had an altercation with the intruder when he was approached by the intruder. Even when his father entered the room and before Martin was incapacitated, the accused did nothing to help his father to overpower the attacker in a relatively small room. Despite his fear that prevented him from helping his family, he was brave enough to follow the intruders when they went outside the house. Rudi's father had to have a clear view of the attacker from the entrance of the room. The accused agreed that his father could have gone around the bed to possibly disarm the attacker and save his entire family. The accused admitted that it might have also given him the courage and opportunity to help his father overpowering the attacker. Instead, Martin opted to fall over Rudi to protect him, put himself at risk to be killed, easy target, and leave the rest of his family behind with an armed intruder in the house. It follows logically that Martin's actions would be more understandable if the attacker was known to him and he himself did not expect intruders inside the house, and whether and how, or if at all, they were armed. Furthermore, the accused disarmed himself by throwing the axe after the attacker. He said hearing the voices made him very unsure as to what was going on. The accused testified that he did not know what his intention or motivation was when he followed the attacker. He witnessed what at least one of the intruders was capable of, but still, he testified. He followed the attacker as it was, quote, pretty much of an effort to flush them out of the house or something, close quotes. The accused left the kitchen door open without locking it when he went back into the house. Sergeant Kleinans found the back door open upon his arrival, whether it was wide open or slightly open. It is strange that the accused did not secure the house as far as possible by at least locking the door or the back door, as the criminals were at large, without at least one of them being wild, ruthless killer. The accused in fact said in his statement to the police that he went back inside the house because he was afraid to follow the assailant and did not know what the assailant had on him. Furthermore, it is odd that such a ruthless killer ran away with at least one other perpetrator, despite the fact that he had been disarmed. There are lots of other knives in the kitchen drawer. It probably would have been easy for at least two perpetrators to overpower the accused and kill him too. It seems odd that the killer would wipe out an entire family and just leave one person. The accused phoned the emergency service from the cordless landline phone. The accused did not check on his family during the time as he fell. He did the most he could. He thought that he did not have the physical capacity to help his family at that point. The duration of the emergency call was exceptionally long. It is strange that the accused did not attempt to stop the blood flow, for instance, from Marli's wounds. The court will take judicial notice that if anybody else, one goes to one's sister's assistance. Instead, he appeared to be content to have this long conversation while every second could be important to save the lives of his family. The accused testified that he did not help or console his family members because he had been taught a bystander could do more damage than good. He also did not think one of his neighbors could help because they were not medical professionals. He conceded they could have simply sat with his family members to console them or comfort them or make them more comfortable even in their dying moments. The accused displayed a peculiar lack of empathy towards the victims during the incident. Instead, he opted to phone his teenage girlfriend several times, albeit unsuccessfully. Conclusion? The court finds that there is no credible evidence to the effect that an intruder entered the estate and the Van Breda residence the night of the murders. Taking into account the type of weapon, the number and nature of the injuries, the perpetrator had to have the intention to kill the victims in the form of dolus directus, unless otherwise indicated. The court has no reason to reject the evidence of the state witnesses. After weighing the merits and demerits of the evidence, their versions corroborated each other in all material respects. And I find that their view and their version, the evidence, to be most reliable. The accused was singularly unimpressive as a witness. Initially, he appeared confident during his quite apparently well-rehearsed evidence in chief. It's more uncomfortable during cross-examination. His answers, besides failing the test of logic at times, were vague on difficult issues, whereas he gave a detailed version on other aspects. He tended to adjust his answers very subtly and contradicted himself in the process. His standard answer to difficult questions implicating him as the perpetrator amounted often to uninformative answers such as, "I should have," without explaining the issue at hand sensibly and adequately. Even if the accused experienced a possible generalized tonic-clonic epileptic seizure or other type of seizure when losing consciousness on the stairs. He was fully conscious and responsible for his actions the period before the possible seizure happened, and therefore he would have known and must have known what he was doing. It was in any event not the defense case that the accused lacked criminal capacity to commit the crimes or failed to appreciate the wrongfulness of his actions. In conclusion, Ms. Galloway argued, and I'm indebted to her for the manner in which she conducted the prosecution, that all the possibilities advanced by the defense ought not to be elevated to fact. Although anything is possible in the realm of ordinary human experience, the following objective facts establish that the accused was the perpetrator of the crime as the only reasonable inference. 1. The victims lived in a security estate with no evidence of any unlawful entry to the estate at the time of the incident. Though not impenetrable, a reasonable high degree of skill, knowledge of the layout of the estate and its security system, and of course some expertise in planning was required to unlawfully enter the premises. 3. Fortuitous unlawful entry was most unlikely. 4. No evidence of a typical house robbery or break-in showing any intruder having been inside the house is evident. 5. 4 of the 5 members of the family were found brutally attacked in a similar fashion and left for dead. The family members were all in very close proximity in the sleeping quarters of the house. 7. The accused was left standing, having lived through the events. 8. The accused presented with injuries supposedly inflicted by the same attacker during the same incident and in execution of the same intent, yet markedly different in nature and extent to that of the rest of the family. 9. The evidence conclusively establishes that some, if not all, of his injuries were self-inflicted. The evidence of Dr. Timmensma and Professor Dempers in this regard stands uncontradicted, despite the accused having had access to several medical experts. The version the accused provided of how the incident occurred is inconsistent with the objective evidence found on the scene. The accused amended material aspects of his version upon becoming aware of the irreconcilability of his version with the scientific and material aspects of the evidence available. Each piece of the evidence on its own might not and is not enough to establish the guilt of the accused. But the cumulative effect of all the pieces concludes the puzzle. Independent circumstances point to the same conclusion.
This leads one to only one reasonable inference. This is true even if the court is to ignore the DNA evidence or the statement of the accused made to the police. With regard to COM 5, the alleged staging of the scene by the accused by inflicting injuries to this person and hitting the axe into the wall above the staircase. The court finds that the accused had sufficient time to tamper with the scene and thus betray himself to be the victim. The accused was the only person who survived a brutal encounter with minor injuries. He had intimate knowledge of the events. The court has no doubt that the injuries to the arm and chest of the accused were self-inflicted injuries for the compelling reasons
advanced by Dr. Timmersma and Professor Dempers. Except for the accused's unconvincing testimony, nothing gainsays the evidence regarding the self-inflicted injuries. The court has no reason to reject or not to accept the evidence of these outstanding expert witnesses. It is not necessary for the court to embark on speculation as to whether the larger stab into the accused's abdomen was self-inflicted or not. It is not necessary for the court to make a finding with regard to the evidence of Captain Brown and Captain Javert that the wall above the staircase was caused by the axe with a controlled action and that the axe was not thrown as alleged by the accused. The accused admitted that he handled the axe at that stage and was admitted by both counsel for the defense and the state that the mark was caused by the axe. The accused admitted that he caused the mark with the axe, and no evidence exists that any of the victims, subsequent to the commission of the crimes, the accused intentionally inflicted injuries upon himself and told the police that the victims and he were attacked by an intruder in order to mislead the police as to the true identity of the perpetrator. Allegations were false and must have been aware of the fact that it might interfere with judicial proceedings which were to take place in the future, or would at least hamper or forestall the investigation of crime. Please rise, Mr. President. After considering all the evidence, the result is inescapable. As a family man, it's difficult for me to say so. It is the only possible inference. In the premises, count 1, the murder of Rudi van Breda, the accused is found guilty. Count 2, the murder of Martin van Breda, the accused is found guilty. Count 3, the murder of Teresa van Breda, the accused is found guilty. Count 4, the attempted murder of Marli van Breda, the accused is found guilty. Count 5, defeating or obstructing the administration of justice, the accused is found guilty. That is the unanimous decision of this court.
He has a clean record. I presume then the proceedings will have to be postponed given the time of day for the sentence. Excuse me, Lord?
Let's see how far we can get.
Yes, okay.
So accused no previous conviction. What do you suggest we do, Mr. Bertha?
Obviously, we also read out a
So
summary.
you'd have to read the whole
judgment.
judgment.
I have to study it. It might be important to get a better impression of what, for example, what you
Yes. No, and also I'll give you a printed copy of this to read.
Yes, absolutely. But for example, we're not entirely sure at this stage what you find. The Lordship's finding, the court's finding was premeditated planned murders.
Yeah.
And that's something that we have to look at. It might be
That
very
is in the
important.
main judgment. It wasn't.
I assume as much. Lord, we are going to ask for a postponement of the matter. I have already, and with great deference court, I have made contact tentatively in order not to waste too much time, and clearly was not in prejudging what your Lordship was going to find. But I made contact with somebody from NICRO, purely to present a court.
How long will that take, Mr. Bertha?
I have spoken to the lady, Lord, and the report would be ready. And again, depending on the availability of the court, obviously, and my colleague, we're looking at 2 weeks from now, the 5th of June.
5th of June?
Yes, the 5th of June. My Lord, again, I obviously need to have a regard to your Lordship's the finding on the merits before I can properly...
Yes, we'll make that available immediately, or tomorrow. We'll email the full judgment to you.
Sorry, my Lord?
We'll email the full judgment to you.
I appreciate it,
but
much,
it's,
but it'll take me
I must
slightly
tell you
longer
that
than
it's,
just an evening to read through that and prepare.
it's unedited, so there are spelling mistakes. They always creep in.
Yeah. So the request from the state is that we, from the defence, is that we postpone for sentencing purposes. It's not going to be long. I simply just want to place the accused personal circumstance before the court.
That's fine.
That's all.
But I think it's a reasonable request for proper sentencing reports.
Indeed, Lord, the state has no objection to
Would you be reading any other evidence?
No, my lord, but we do have one victim impact statement from one of the family members of the accused, and we are in the process of consulting with another witness to obtain a similar statement.
So there's a postman would suit you as well.
It would indeed, Lord. However, there is the question of the accused having now been convicted and him being released on bail pending the sentencing procedure.
I'll just check what date is that.
The 5th of June, it's a Tuesday.
Let's see what is a Tuesday.
We
Let's
are
look at our
available.
calendars.
We are available for the 5th to the 7th of June.
Can we set this down for 2 days?
Indeed, Lord.
5th and 6th of June?
That would suit us.
Rhoda, do I have anything else? So that sorts out that matter. Any further matters?
Lord, as I've mentioned, the question of the accused being released on bail pending the sentencing procedures, as he's now been convicted, we have prepared heads of argument for the court, my Lord. We raise our objections for him being released on bail pending an appeal, pending sentence and or appeal.
Lord,
In the light of the nature of the findings of the court,
brief him, Lord. Clearly, Section 58 of the Criminal Procedure Act comes to play. And it states in terms that the Lordship will now obviously take into account that he has been convicted of the offences that he was charged with, and secondly, the likely sentence which the court might impose. But subject to that, and also, of course, given the fact that it was, with respect, common cause between the state and the defence, that exceptional circumstances did exist, and that's the reason why the accused was afforded bail more than a year ago by agreement between the state and the defence. And since he has stood and complied with his bail conditions, he never arrived late at court. He complied fully with the amended bail conditions recently when he travelled to see his grandmother. I have mentioned to your Lordship as well in chambers that there is
Mr. Boer,
chance.
I don't want to interrupt you if you're here fully, but in the light of the very serious nature of the convictions, it seems proper that bail be withdrawn at this stage.
Lord,
But subject to proper arrangements being made for the medical treatment.
I take your Lordship's point, but with respect, it needs to be seen in context. With respect, given the very stringent bail conditions that were imposed by way of an amendment when he travelled up to, I would venture to say that the possibility at least of my client being convicted before today was very real to him. But despite that, there was never an attempt to him on his part to escape. And if your Lordship, for example, would wish to impose very stringent that he would physically be placed under house arrest, subject only to consulting with us for purposes of the sentence. The lady from Nicro who has the social worker that I just simply want her to compile a very short report about the personal circumstances of the accused. Again, it makes it simply just much easier and much more certain that we will have such a report by the 5th of June if your Lordship were to reimpose the bail. The amount is quite substantial, and like I said, I would submit, if he now has to report every single day or even twice a day to the police station, then so that can also be arranged. I also need to point out to your Lordship that my instructions are that the accused is on chronic medication at this moment as well for the epilepsy and as well as antidepressants. And your Lordship, I need not point that out to your Lordship. Your Lordship was inspecting judges of prisons for some time, and your Lordship was also the chairperson of the National Council for Correctional Services. And with great deference to the correctional services, the possibility of, especially awaiting sentencing prisoners, to have access to proper medical care is very difficult. If your Lordship is going to find against me and make a finding that my client be held in custody until the 5th, I am then, in light of that, going to ask your Lordship that your Lordship then endorses or consider endorsing the warrant that he be held in the hospital section of Portsmouth, that we can ensure at least that he continues with his medication until such time. Once he's sentenced, things change, and then prison, the correctional services must take its course. So those are the two options, Lord, and I would firstly, in summary, ask your Lordship to reimpose, to reinstate the bail. If there,
But Mr. Botha, can I, now no longer chairman of the correctional services, instruct the correctional services where and how to detain the accused? I can make a recommendation, yes.
yes, but
I can't compel them to exercise.
I have it on very good authority from one of some of the senior staff of the police members who serve as court orderlies, that if your Lordship were to make such one, that in fact will be carried out.
He is to receive medical treatment on trial.
In fact, he's on chronic medication. That is
Yes,
no
but
doubt about it.
chronic medication means nothing, Mr. Botha. I've been on chronic medication for 35 years.
Mostly, but I wouldn't say it means nothing, Lord, but of course it makes it more difficult if you...
Yes. Yeah, it depends what you get the chronic medication
Absolutely.
for.
And it's vital that he gets that medication.
Ms. Cameron? Ms. Cameron?
My Lord, firstly, just with regards to the previous bail of the accused, that ceased the moment the accused was convicted, my Lord. Bail is only valid for up until the point where the court gives a conviction. And it can only be extended if the court so grants it. So it's not automatic that the accused will be afforded bail. My Lord, with regards to the aspects why the state opposes bail, it's already been elicited by the court that it is very serious offences that he's been convicted of. We deal with those aspects on paragraph 3 of our heads under the heading seriousness of the crimes, my Lord. In fact, as Mr. Botha has pointed out, the possibility of a premeditated commission of counts 1 to 3, it carries a minimum sentence of life imprisonment on each count. The second aspect why the state at this point in time is opposed to the accused being released on bail, my Lord, is page 4, the risk of a flight. Lord, it is conceded that the accused has cooperated with the police since his arrest and appeared at all dates and times the matter had been postponed to and that he complied with the conditions of his bail. Lord, but again, at this point in time, the accused has now been convicted of very serious crimes and his circumstances has radically changed. We refer the court to the case law state this is Brainkies in that regard. Lord, even if it was argued that as it is not, that the accused at this point in time is not in possession of valid travel documents, my Lord, in state visits for Mark, that was shown to be not an issue for a person who has the means to obtain travel documents. My Lord, we are of the view that the accused's personal circumstances ought to be considered at this point in time. In paragraph 19 on page 5 of our heads, my Lord, we argue that the following should be noted, that due to the nature of the crimes, his relationship with the remaining family member is strained. His family ties are therefore limited. The accused rents accommodation and has no fixed address. The accused has no fixed employment. The accused does not derive his own income and can thus, with all due respect, afford to forfeit an amount of bail. And the accused's financial position would enable him to flee to any country, and any attempts to trace him would be difficult, especially should he flee to a country without any extradition agreement. Furthermore,
What's the order? Like, his bail is not extended or bail is not?
that his bail is withdrawn, my Lord, and
Isn't that automatic?
it is not, yeah, that his bail is then cancelled, formally cancelled, and it to be kept in custody until the sentencing procedures, my Lord. The state has no objection if the court makes an order that he be kept in the hospital section. I'm also aware of the practice that it can be done by enforcement. If it's necessary, my Lord, the state will also endeavour to assist that takes place, my Lord. And maybe at that, just on that point, my Lord, maybe an objective diagnosis then again of the accused state of health.
Thank you, Ms. Cameron.
Very briefly in reply, none of the issues that my learned colleague has now raised, subject for one, that's now conviction. None of that has changed. All of those aspects were in place when the state agreed with us right at the beginning that they are exceptional circumstances. Nothing has changed. He rented a place at the time. We, in fact, stayed with a family member at the time. It wasn't working. Everything else was exactly the same. Nothing has changed. Nothing, not a single thing. Yes, we have on the one side of the scale the fact he's now been convicted. But he was facing the very same charges before, very serious ones, same situation. There's nothing else. On the other side of the scale, Your Lordship also has now to do with a person who has shown that he is willing to comply with these bail conditions, in stringent bail conditions. He never did not adhere to those aspects. There's no indication at this stage with respect that he will abscond. In fact, he'd be very silly to abscond because nobody in this country doesn't know what he looks like. I mean, where will he be hiding? And there's no indication that, my Lord, that he has that he has access to funds that will enable him to pay for a false passport, etc. There's nothing like that. If he wanted to abscond, he was reporting on Mondays and Fridays. He could have absconded. He had 4 days in between, and when he had months now, but when the court was not sitting. With respect, there's nothing before that you can suggest remotely that my client is going to abscond. On the other side, I've explained to Your Lordship this morning, clearly not a life-threatening, but it is something that my client needs to undergo. On Your Lordship finding that no matter what, he's going to go to jail, there's no doubt about that. He knows that. But on that finding, the kind of operation that he requires, he now can get and pay for himself. And it's a 2-week postponement. Your Lordship, if Your Lordship wishes to make the one bail condition change that instead of only reporting on Monday and Fridays, that Your Lordship, his bail is extended and he's ordered to report every single day between 8 in the morning and 8 in the evening. Then he must do so. And with there can be no problem, and there's no indication that the general society will view that Your Lordship is being light on crime. With respect, absolutely not.
Anything you say?
There is a further aspect that changed now, which we refer to in our heads as well, Lord, and that is the interest of the community, Lord. At this point in time, I refer the court in...
Yes, I'm fully aware of that.
Indeed, Lord, that the interest of the community also plays a role. That what message will send out that a person who's been convicted of a very gruesome and brutal vicious crimes are allowed to go out for 2 weeks just pending to be sentenced.
Thank you, Mr. van Breda. This is an equally difficult decision to make, but you have been convicted of very serious offences. The situation is now different to what it was a few hours ago. You're now a convicted individual as the one, and I think the interests of society dictate that you be detained, the community interests dictate that you should remain in custody. I'll go along with the reasons and this request made by Advocate Galloway that your bail be withdrawn and that you be detained in custody. A bit concerned about the suggestion that you'll be detained in hospital section because of perhaps it's the wrong reason, perhaps of the adverse publicity which hospital sections of prisons have required over the last few years. What I would suggest is this, that your bail be withdrawn, that you be detained in custody, that the correctional services detain you at the hospital section of Portsmouth Prison, subject to you providing adequate medical certificates of your condition. Mr. Worker?
Lord, my it obviously will take some time, but Your Lordship be inclined to just give all forwarders an opportunity to get those medical certificates and get them to the...
Ms. Galloway got no problem.
Pending that he be
It may take a few days to get the medical certificate.
Indeed, Lord. In the meantime, the accused still to remain in custody.
Yeah, okay. He stays in the hospital section until such time as you're able to get medical certificate.
We should be able to provide them by no later than Friday.
I'll leave it to you. I'm giving you more than that.
I'm indebted to you, Lordship.
Mr. Bertha, Mr. van Breda, you understand that? Thank you. Ms.
Lord, may I
Paulson?
just tell you one thing? Your Lordship has not cancelled the bail because he's entitled to the bail, is entitled to be paid to him.
Yes, he can get the money back.
Yes. I just want to make sure that he's not cancelled the bail.
No, no, it's
My
not
lord has
cancelled.
asked for it.
No, no, the bill's come to an end, actually. Yeah. Thank you. Ms. Paulson, Archibald.